Today, we're talking about how important the Fifth Amendment is for people like me.
Tom killed himself and he literally gave me the bird. And then the state of Florida decided that I must have killed Tom. And they have been giving me the bird ever since.
Welcome back to another exciting episode of Giving Me the Bird. I'm Shannon Gallagher, your friendly accused murderer. And I'm here again with my expert criminal scene investigator, David Zeliff, with a wealth of experience who's taught me more than I ever wanted to know about these topics. Today, we're talking about the Fifth Amendment. So, Dave, in teaching people over the years, what have you wanted law enforcement officers to understand about Fifth Amendment protections?
I think the one thing is with Fifth Amendment rights is that you can do them verbally. You don't necessarily have to do them in writing, but I always recommend doing them in writing. Why? Because what I teach is, I want to treat that person that I'm getting ready to interview the same way I would want to be treated if I was sitting in their position. So what I do is ensure that the information on the rights advisement form is completed and that we go through them together, go through them step by step, reading all the rights and then asking all the questions at the end. Did they fully understand it? Are they willing to talk to me at this time? And are they willing to talk to me without a lawyer being present? And they have to understand that at any time during that process, they have the right to stop talking to me.
They can change their mind.
They can change their mind. But what I've traditionally found is that once you're done with the rights advisement form, you put it away. And a lot of people will continue to talk to you, especially somebody that hasn't done anything. And sometimes people that will continue talking to you.
Okay. So when we're talking Fifth Amendment rights in this arena, we're talking about what everyone calls Miranda warnings and how those warnings are best given and when it's necessary, right?
So,
It's not always necessary, right? There are
Right.
some times there wouldn't be a need to issue Miranda warnings.
So I have taught this for many years on the civilian side in colleges and universities. I also dealt with it on the military side, in which, military personnel, there is no such thing as non-custodial interviews of military suspects.
Which is very different from civilian context. Right?
And so they are Mirandized regardless. When sometimes you may be interviewing somebody and you're thinking that, this person is a witness until something caused me to stop and say, okay, wait a minute. This just moved into the suspect category. And as soon as that happened, I'm going to advise you of your legal rights for this offense because I want to ask you questions about this specific offense.
Here, though, when I consider the actions of the different police on scene and then the explanations that we've been receiving during depositions we've been taking, I think there's no question that people came to this scene believing this was suspicious all the way up that this was a homicide. Your first reporting officer is contacting his supervisors for them to come out and send some detectives out to report to a homicide.
So there's two factors on the civilian side. One factor is, are you in custody? If you're not in custody, then I can talk to you as a suspect. I don't necessarily need to do Miranda warning.
And this is a very interesting topic, but can I hold you there for a moment? You've seen the body worn camera footage. I lived through the experience and I can tell you, I most certainly believed I was in custody. Looking back at it, after leaving the scene and getting my bearings again, coming out of the intense trauma I had just experienced, appreciated that I was in custody. We've had people in this case say that they didn't think so. One position is that because I was not placed into handcuffs, I was not in custody. To me, that does not seem applicable. And I haven't found any case law that supports that. What's your take on the need for handcuffs for someone to be in?
It's not. And again, what I teach is the basic concept of going to a restaurant and having a waitress that's busy and you want to interview her as a suspect. Okay. And I say, okay, Mrs. Sullivan, I'd like to interview you as a suspect in this case. Do you have a few minutes? And she says, Mr. Zeliff, I've got to go wait on these two tables. When I'm done, I'll come back to you. And I say, no, you need to sit down now and we need to get this done. As soon as I've done that, then I've taken custody of her.
Okay.
What I used to tell my agents is not, if you invite somebody to the office, it's kind of borderline. If you're inviting them to the office to make a statement and they come to the office, I always recommended that at that point you advise them of their rights. But if they voluntarily came to the office, then it might not be necessary.
I think
And
having
so-
lived through it, I feel it's pretty clear and easy to understand what you're saying. You're a suspect in this case, and I need to advise you of your rights, these Fifth Amendment rights. If an officer were to do that, many people, I'm gonna guess, would clam up. They're not going to want to talk. If anyone had said to me that morning, Miss Gallagher, we're considering you a possible murder suspect. Now, tell me everything. I would have said my lawyer's name is.
So I got to tell you that, it depends. Sometimes what I've seen is somebody that has actually done something may be more apt to talk.
Interesting.
And sometimes it depends on, for instance, the shock factor, right? If I tell somebody, hey, I need you to come by my office tomorrow and talk to me, and it's a young agent, let's say, and I say, hey, you need to come and talk to me. I'm the inspector general, and I need to talk to you about something.
Okay.
And so they're freaking out. They're freaking out because they're thinking, oh my gosh, he knows I took that pen home from work, the government pen home from work. So they're thinking about all these little things that it's not what I wanted to talk to them about. As soon as I advise them of their rights for murder, they're like, oh my gosh, relief. I didn't kill anybody. I was worried about that pen.
Right. Okay. That does.
And so often they'll talk because they want to clear that up.
You said that even guilty people would actually talk.
Yeah. And often would stay because, for innocent people, for people that haven't done anything wrong, a lot of times they don't want to spend the time. They have a life. They have things to do, and they're asking to leave.
Right. So, okay. So that's the first part of it. And then you said that the second thing was you would let them know that you want to speak to them because they are a suspect in connection with a certain crime. And then what's the other part of that? So when you give that notice, that would apply in a situation where the person is in custody. What about if the person is not, you don't consider them to be in custody? So let's talk more about what it means to be in custody.
And then you have a third category of communication, which is spontaneous utterances. And spontaneous utterances, for instance, when I go out and arrest someone, I would advise them right away, once I've searched them and put them in hand irons and explained that, hey, I'm going to treat you the way I'd want to be treated. And when I have to put you in hand irons to transport you in my vehicle, and explain to them that, look, I want you to remain silent until we get back to the office. When we get back to the office, I'm going to get you a cup of coffee and we're going to talk about this. And I'm going to advise you of your rights, and then we'll go from there.
All right.
And so get them in the vehicle, and on the way they say, I knew you were coming. I have no obligation to stop them at that point. I've already warned them not to talk. And so that might be classified as a spontaneous utterance.
In that context, so the custody element seems to be satisfied because they are going with you to the office and they're in your vehicle,
yes,
which is different to me than even bring yourself over to my office. And you've already admonished them of their rights.
Yeah. I've told them that they're under arrest.
In this case here, there's a protocol in place in the context of a homicide scene. And to start with, the homicide scene protocols for the Fort Lauderdale Police Department are supposed to be applied in cases of suicides or any suspicious death, right? So I'm including anything that could have been on the table in this instance, should have been treated as a homicide, right?
Which is a good policy, actually. I mean, I think that is what we teach. I think that's what Steve teaches. I think in his book, on equivocal death, that's what he says is
right.
that, an equivocal death should be handled as a homicide because you're going to cross all the T's, dot all the I's. You're going to do what needs to be done to prove or disprove.
Well, and certainly I think that it makes sense to just about anybody that if you're going to charge someone potentially with a crime that carries an extremely long prison sentence, in the case here, I was charged with premeditated murder with a firearm. If convicted, that has a mandatory sentence of life in prison without the possibility of parole. The only other potential punishment for premeditated murder with a firearm in the state of Florida is actually capital punishment. So we're talking a serious offense. So shouldn't we take the time to really investigate that kind of case?
I'm a firm believer that if you take shortcuts and don't follow policy in a housebreaking larceny, then you're going to do the same thing when you get to these serious cases. I don't think shortcuts. I don't think sloppy work. I don't think non-adherence to standards. I don't think confirmation bias. I don't think lack of supervision should enter into any single criminal investigation, period. Prove or disprove. Your job is to prove or disprove. It's not to prove a crime. It's not to prove a level of a crime. It is to prove or disprove what happened in this particular case.
And I look at this here and I think, wow,
thorough.
There's a lot of evidence that did not fit into the theory or that fell through the cracks. In Fort Lauderdale Police Department's protocols, they have called out extra care that they wish to have applied in the case of any homicide scene. And that all those homicide scenes include possible or likely suicides, because you just don't know until you've done that investigation. So with that extra amount of care, you're supposed to be getting statements from anyone who was a witness, one who's a victim. Now, to take that statement, if the person's in custody, here in this case, for some 5 hours, my husband and I were watched by 2 armed police officers. If we wanted to come inside the residence, that wasn't acceptable, but that you could say was just to protect the sanctity of the crime scene. But if we wanted to walk down the hall, that wasn't allowed either. Wanted to go downstairs to go to the restroom, we had to do that with the guards who were there looking over us. And so to me, that's custody and control. And even on a more simplistic level, once someone says, I want to leave, I want to go home. If you say you can't go home, you can't leave. Now you have that person, you've asserted your authority over the person.
Unfortunately, because they had so many people interfacing with you and your husband, I don't think any of them have a real overall picture. It's just like someone saying, one of the detectives saying, yeah, you were free to leave. Well, was I? And here's how I asked, and they said, no,
Right.
You need to stay here. And he's like, oh, well, that was probably just to answer some more questions from the detectives. Okay, right. But they did tell me that I couldn't leave for that reason. Exactly. And what am I supposed to do, right? Like, I mean, Taras was supposed to go to work and he was not allowed to leave. And so, I mean, it's custody.
To me, I completely agree. Why would we allow those statements to be taken? If it's borderline, to me, play it safe. Go ahead and issue the warning.
Honestly, at the very beginning, a proper procedure would have been to separate you from your husband.
You've explained that to me. Yeah, and it makes sense. And it's in the book.
And then detailed statements from beginning to end, not one officer getting, the first few snippets and the next officer getting a couple more snippets in your traumatized state. I can tell you for me, based on the fact that you were traumatized at the time and Taras needed to go to work with the circumstances at the scene, once I had the warrant, my focus would be on processing that scene, and I would have allowed you until the next morning to recover. And then the next morning, done the interviews back at the office for you and your husband.
Like the same kind of courtesy that a police officer is often afforded after an officer related.
Yes. Well, for a lot of other crimes, I mean, sexual assault victims that are traumatized, you have to give them some time, and they need a victim advocate. And that's the other thing. I would have got you a victim advocate, and that would have helped too.
What the Fifth Amendment does in the context of a criminal case is to protect a person from giving testimony that will ultimately harm themselves. So our goal here is to not have someone have to bear witness against herself. And that has to be handled in a certain way. If you really want the statement, that issuing that warning, the person can still make a statement.
I think, you're looking for the truth. And in the end, I want you to be able to provide a truthful statement from beginning to end. And so I think that has to be captured in the right way. And the way things were done, it was very chaotic.
Yes.
And so in the end,
it was all done without, part of the problem I have is that I feel that the officers, even prior to arrival, were treating this as a crime scene.
Yeah, you had a split. You had some that did and some that didn't. That goes to the leadership, right? The leadership of the Fort Lauderdale Police Department has created a policy that's pretty good.
A written policy.
A written policy that's pretty good.
Right.
But in the end, it's adherence to that policy.
Right.
And so I think adherence to that policy and handling it as a homicide from the very beginning. I mean, because you're going down these two pillars. And I think it would have created a much better product in the end.
Right. And again, this is back to the whole topic that we've discussed in terms of the Fourth Amendment search and seizure issues. If you actually have someone who's done something wrong and you fumble in terms of these important constitutional protections, you could lose the case over that. All the time, cases are thrown out because of officers failing to abide by the requirements of Fourth Amendment search warrant rules and Fifth Amendment Miranda warning rules. And that should concern people, because if someone is a danger to society, you should want them to actually be able to be apprehended and sentenced based on fair proceeding. So I appreciate those comments. Let's see. Trying to look over my notes about Fifth Amendment. Okay, so testing for gunshot residue and the photographs that were taken, more of a Fourth Amendment issue.
For me, part of the legal background on that, at least in training for me, would be, I think it's Terry versus Ohio with the stop and frisk, right? And stop and frisk has become very controversial all over the place because it's being abused and misused.
Really, really dangerous for a lot of society.
Well, and so they, and there's, if it's done correctly, it can be a valuable tool. And that goes to training, right? You can't have people out there that don't fully understand. And this is kind of what concerns me about all of the things that we've heard in regards to why the Fourth Amendment wasn't adhered to. It's like, is this part of your training?
Right.
And for me, if you don't understand what you're doing from a legal basis while you're out there, this is where supervisors, again, should be kicking in and saying, hey, guys, you know that you need a warrant. Get yourself a warrant.
There's a policy in place in the case of a homicide, which includes all suicide investigations, where you need a supervisor involved. And there's also, you're supposed to have meetings after the fact, again, with supervisors involved.
This is what I'm used to, supervisors looking at that case the next day and saying, let's get the warrant done or get consent or whatever the case might be. But those things, there has to be some follow-up on these things.
And in this case, in terms of the fact that there was no warrant sought for the scene, the range of reasons why that wasn't necessary, according to the police, shows not just that there's no supervisor looking over the situation, even the one who's present at the scene, but you've got all these different excuses. Not needed because of exigent circumstances. It's not needed because you invited us in. It's not needed because you didn't reside there. It wasn't your regular abode. It's not needed because of reasonable suspicion. None of these explanations, in my opinion, move the need for a search warrant for that scene. I've spent hours researching this, trying to see if any of the explanations and excuses offered by Fort Lauderdale Police Department hold water. And I don't think so. But, now we're in the same kind of scenario with the Fifth Amendment. Fifth Amendment.
So if I look at it, though, how many people have reviewed this case, right? I mean, like somebody had to review it in order to say, this is what the charge is going to be, right? And then at the police level, at the law enforcement level.
So you're thinking about in terms of when applying for search warrants, for example, that's one place where you need to state, that's right, what's the offense? So the judge can assess, are the things that you're asking for related to this offense, right?
Let's move up to the prosecutor's office. I mean, for me, I've worked with federal prosecutors, OD prosecutors, state prosecutors. I've worked with Korean prosecutors. I've worked with German prosecutors. And in that process, it's a give and take, but there has to be a mutual understanding, because it may be that I go in now, federal prosecutors are a lot more hands-on.
Okay.
And so they may be more involved in regard to like, hey, look, this offense, I don't think we aren't going to get this. But this offense, I think, if we were able to get this, and this, we might get there.
Okay.
And so there's a discussion in regards to how well have we established each of the elements of proof for this offense. And so when you're investigating, you have to think about all of the elements of proof of the offense that you're investigating and how are you going to establish those. But by the same token, you also have to look at any of those outside things like alibis, motive. And so all of those things are important. And to be thorough, if a defendant gives you information, like you need to interview these people, you must do that. You must do it, because I've seen young agents that were given an alibi and they didn't go and do it. And that will bite you every time.
Also, I feel like there's a lot of, in addition to passing the buck and pointing the finger at the other people who could be responsible for some failures that we've been able to point out, don't you actually care what happened?
what I'll say is I heard something that concerned me in testimony. And that was that I put those things in my report that proved
my case. Right. And
I
there was
wanted
the
to
second
say-
half of that statement. I said, so what about including exculpatory information in your report? And to say there was no exculpatory information.
So that's a decision that was made because they're not looking at anything as exculpatory when there was multiple things that are exculpatory. So it's a mindset of prove the case instead of prove or disprove.
I agree wholeheartedly. That's how this investigation was conducted. Why would you care if you Mirandized your suspect? You're definitely not worried about whether you're giving that person the due process to which they're entitled, right? Don't forget the due process clause also comes from the Fifth Amendment, and that's our topic of this discussion.
I can't wait to get up and get out of here. The system tapped into my deepest. Never be here again, I swear. Up here. Is that a feeling that you've ever shared?